All right, welcome. We're still continuing our conversations regarding this address or letter or communication from Atiku Abubakar's lawyers to Nigeria's courts to tell them not to look the way of technicalities, but to consider the merits of his application for leave to submit fresh evidence in his appeal against the electoral victory of Bola Tinubu. Joining us is Jimmy Abia, is a lawyer and public affairs analyst. Jimmy, good evening to you.
Good evening. My pleasure being with you.
All right, and via video link we have Victor Riola. He's a political analyst. He's in Lagos. Victor, good evening to you.
Good evening. Thank you for having me.
All right, Jimmy, let's start with you. You're a lawyer. Speaking on the issue, that we have on the table now, the argument in the reply from legal team Tinubu to the application for leave to file fresh evidence by legal team Atiku, what legal team Tinubu is saying is that this is an issue of, or the issue of his qualification is a pre-election matter. Now, generally speaking, without trying to plead the case of any of the parties involved in this one, are such issues of qualification of candidates considered pre-election matter?
Well, yes. Issues of qualification of candidates are actually pre-election matters. But issues of disqualification of candidates can also be post-election matters. Now, there's a thin line here. Now, there are factors that disqualify a candidate from being qualified to contest an election. And those include if someone has submitted, for instance, if someone has submitted a forged document, now the person will not be qualified for that election. And it is actually something that is a post-election. It also falls into post-election matters. So it depends, of course, it will depend. This is now subject to whatever the court will decide. The matter is in court now, but based on, decisions of court, existing decisions of court, such matters, have been treated as post-election matters also.
Quite interesting. Over to you, Victor. I want your thought on the issue of allegations of a forgery and perjury labeled on Tinubu by Atiku in his petition, and this fresh evidence he wants to submit to or wants to be allowed to be submitted to the courts. As far as you're concerned, how serious is that twin offense of forgery and perjury, and what are the implications as far as you're concerned for President Tinubu if he's found guilty of these by the courts?
Well, thank you for having me once again. I think since the Supreme Court has given a date, I think the court we had the case on Monday. I don't know, so that we don't kind of a prejudicial and speaking about the content of the what is before the Supreme Court. That said, I think what is going on in Nigeria is about our value system. It's about the constitution that we operate. Even if you look at the constitution critically, what is even the entry requirement for those who want to be president, who want to be governors? It's an evidence of a school certificate, not even school certificate pass. Whereas if you want to enter into a university, you need 5 credits at not more than 2 sittings. So even at the level of school certificate, you see a lot of people, a lot of forgeries among senators, among House of Assemblies members, among governors. So what do you expect? So what is going on in Nigeria is we need to go back to the basics. We need to look at our constitution critically. Because I doubt if anyone who want to hire a school cert fail or someone with evidence of a school cert to be a chief executive officer of his company. So if you look at what we are operating, it's neither here nor there. So we need to look at this thing critically and look at our institutions. Because if we have the DSS, we have the INEC, that are responsible for all this. There should be a kind of a clearing house. How did some of these people get through all these institutions without being noticed in the first place? So that otherwise, this will have saved us all this hoopla, and instead of that the whole world is now beaming their searchlight on Nigeria. So I think first and foremost we need to go to the basis. If you look at the condition that we are operating, the requirement, the criteria set for president, for senators, those who make laws for the good of the nation, for the good of the people, I don't think is something to write home about.
All right.
Because if you're asking.
Okay, thank you, Victor. Because of time, I'll quickly move over to Jimmy. Jimmy, what's your take on the technicality conversation where Atiku Abubakar is saying, hey, the courts, you have to look at this case on its merit and choose justice over technicalities. In your opinion, can issues of merit be determined or pronounced upon at the interlocutory stage?
I couldn't get you very well. Please.
Okay. So I'm saying, what's your view as far as the law is concerned on the conversation surrounding going the way of technicalities versus going the way of justice or merit, as Atiku Abubakar has written in his response to the objections of the Tinubu team to his application for leave to file fresh evidence. He's saying to the courts, do not look the way of technicalities, but go the way of justice in my application to file this fresh evidence. So what do you think about that as far as the laws are concerned? We're asking you, can issues of merit be determined or pronounced upon at the interlocutory stage?
No, issues of the merit of a case would not usually be determined at interlocutory stage. So that is taken. That is a basic a trite legal principle. So it will not be taken. The merits of a case will not usually be taken at the interlocutory stage. But that being said, when it comes to issue of whether justice or technicality, I'd say that it is always better. It is always better for the courts to look beyond technicalities. It does something for the society. What it does is that it sort of lets everybody understand the basics of the decision. For instance, if there is a decision and the court, like in the case of Lawan, where the court said that this action, was filed via another protest, where it was filed via a different format. It could have come by writ, but it came by originating summons. So because of that, now people will not have that intrinsic confidence in the judiciary because they would believe that the particular issues, the nitty-gritty of the matter would not have been determined because the court actually dealt with technicalities. So I actually think, and I've said this in several fora, that for the people to trust the judicial system, that the judicial system must make conscious effort to determine cases, not on the basis of technicality, but on the basis of the justice of the case.
But Jimmy, very quickly, there is the argument that election cases are different from civil cases, obviously, and they are special. They are sui generis. They are under specific, strict laws, and so you don't have the liberty to choose whether to even use the term technicalities. But everything must be looked at from the premise of the electoral law, the Constitution, and all that. What do you say to that argument?
Well, they often, it has been stated often that election matters are sui generis, but people should not take this out of context. When they say election matters are still cases that are meant to be decided on precedent, that are still meant to be decided by justices, that are still meant to be argued by lawyers, that are still meant to be based on the law. So election matters being sui generis simply means that there are rules, set up, for instance, in the Electoral Act, and basic rules set up in the Constitution, which will guide election matters. But that, a number of persons have, tend to take this out of context to mean that election matters are like rocket science. No, they are not rocket science. They still have to be decided based on the justice of the case. They still have to be decided based on precedent. They still have to be decided to achieve justice and to achieve trust for the judicial system. Because where the people lose trust in the judicial system, where technicalities are applied such that you have absurd decisions coming out of the court, the confidence of the society.
Okay.
Because justice is rooted in confidence. The confidence of, and if the confidence of society declines in the justice system, then we have a problem within that system.
Jimmy Abia, we have to go. Victor, I sincerely apologize because of the want of time. We had some issues getting both of you on. I am so sorry. We'll have to create another time to discuss this. But I wish we had both of you and liberals in the same room so that we could have a very, very interesting debate. But thank you very much, Jimmy Abia, lawyer and public affairs analyst, and Victor Aurelia, a public affairs analyst. Gentlemen, thank you so much for your time.
Thank you.